Premeditated first-degree murder. How do you get that wrong? Aggravated battery, December 1st, right here. You can't tell me I wasn't. I was trying to tell me I wasn't. The lady dismissed it. You can't tell me I wasn't. They go to paper right there.
What you're talking about is the clerk's website.
I'm talking about the no action. You changed the no action from another judge.
Can I finish? First-degree premeditated murder with a firearm.
She is my attorney. She know what's going on. She know that this charge was dismissed. I ain't even supposed to be in jail. Ain't nothing. I gave a statement. I need help from Donald Trump, them, and all the black people out here. If y'all listening, please help me. They trying to kill me. They lying, falsifying charges. If y'all see this on Facebook, come and help me.
On February 14th, 2026, Mr. Sledge appeared before the court facing serious felony charges, including attempted first-degree murder with a firearm, aggravated battery with a deadly weapon, possession of a firearm by a convicted felon, tampering with evidence, and false imprisonment. These charges stemmed from an incident on December 1st, 2024, in which a woman was allegedly shot in the leg. Sledge had been sitting in jail since his arrest and had recently fired his public defender, demanding to go to trial immediately. He claimed he had filed for a speedy trial the day he arrived at the jail and insisted there was no evidence, no witnesses, and no reason for him to be in custody. But when the hearing began, what emerged was not a defendant calmly asserting his legal rights. It was an unhinged torrent of accusations, conspiracy theories, and outright hostility directed at the judge, the prosecutor, and the entire justice system. Sledge claimed the court had falsified paperwork, changed charges online, arrested him without a warrant, and was now trying to kill him because he was a black man. What Sledge didn't seem to understand was that every accusation he hurled, every interruption he made, and every conspiracy theory he spouted was being recorded and could be used against him in ways that would make his already desperate legal situation exponentially worse.
Trump, them, and all the black people out here, if y'all listening, please help me. They trying to kill me. They lying, falsifying charges. If y'all see this on Facebook, come and help me. Send Oprah Winfrey, all the people, because they harassing this black
Mr. Sledge, do you want me to read this, or do you want me to listen to you?
This is Mr. Sledge. I talked with Ms. Rivers this morning. We have not received an order appointing our office, but my understanding is that the public defender's office has been relieved. I was just advising Mr. Sledge, you know, hey, I need to continue the case. I did read a police report this morning, but that was the first appearance police report. So other than that's the extent of my knowledge.
I got everything. You want to go right now?
No. I'll have it.
It's my understanding. I believe I signed the order already, but with everything seemingly stuck in the queue, I can't say that I did. So if y'all can make sure that an order has been signed.
I have seen it, Your Honor.
You've seen it? Okay.
Yes.
Your Honor, just to clarify for Mr. Sledge's benefit, the court did relieve the public defender's office.
Yes, I believe a written motion was filed, and Mr. Sledge, I think you had made some comments at our last hearing, which was the bond hearing, that you didn't want her to represent you anymore.
You have that on record. I said I'm ready for trial. What I've been saying for the last 6 months, I ain't on. If that the case, why would she represent me for the bond hearing? You shouldn't have let her represent me for the bond hearing.
It's my understanding, if I recall correctly, after the motion was over, you told her not to come see you anymore.
No, I told her don't come up there until we go to trial. I'm ready for trial. I put in for a speedy trial. As soon as the day I came to jail, I didn't go to first appearance. I supposed to been at speedy trial months ago. It ain't no evidence, ain't no witness, ain't nothing. Y'all done took all my stuff. I got the thing right here. It ain't even no warrant. It's an affidavit. It says it does not have. You done changed the charge. The lady dismissed it. She was my attorney when it was dismissed. The state attorney right there, she dismissed it. I got the paperwork right here. It was no action on 12/11, and then y'all trying to bring it back. I don't want that. I want y'all to take the thing off of that. That's why I kept telling you about the bond here. It don't need to be now. That's what I'm telling you. This lady is not, that's why I said she don't need to not to be fired, because I want to go to trial with her, so when they go to trial, that way the people know at the district court appeal, because I'm writing them and shitting them all my paperwork already. She is my attorney. She know what's going on. She know that this charge was dismissed. I ain't even supposed to be in jail. Ain't nothing. I gave a statement. You ain't supposed to take me to jail for giving a statement. And then I got tased the other day at the county jail. I really need you to look at that. Can we talk about that for a minute? Because I know you can help me with that.
That's nothing to do with me.
You show, because you filed this false paperwork on me. You tried to make it look like I've been coming in front of you instead of judge gonna tear it. I got the paperwork right here where you changed it online. Yeah, the summary. You changed. I got both of them.
I changed the summary.
Yeah, you changed the summary from
What did I
12 to
change,
12
Mr.
five.
Sledge?
You want to see? Hold on.
Sure.
I got it right here.
I mean, if you're going to accuse me of committing a crime, I'd like to know what it is.
I'm gonna show it to you right here. This is because already I was charged with premeditated first-degree murder for somebody that wasn't dead. So the police department done lied already, right?
The hearing began with Sledge's newly appointed attorney explaining that he had just been assigned to the case that morning and had only reviewed the initial police report, so he needed time to prepare. But Sledge immediately interrupted, insisting he was ready to go to trial right now and didn't need any continuance. The judge attempted to clarify the situation, noting that at the previous bond hearing, Sledge had told his public defender not to represent him anymore. Sledge corrected this, claiming he had only told the attorney not to visit him until trial because he was ready to proceed immediately. He then launched into a rambling tirade about how he had requested a speedy trial the day he was arrested, that there was no evidence or witnesses against him, and that the charges had been dismissed and then mysteriously brought back. Sledge's central claim was that on December 11, 2024, the initial charges of aggravated battery with a deadly weapon and possession of a firearm had shown no action in the court system, meaning they had been dismissed by his previous attorney. But then, according to Sledge, the court had changed the paperwork online to reinstate those charges and make it appear he had been in front of a different judge on different dates. He waved documents at the camera, insisting he had proof of this conspiracy. He also claimed he was originally charged with premeditated first-degree murder for somebody that wasn't dead, which he argued proved the police had lied from the beginning. When the judge attempted to respond, Sledge talked over him, accusing the judge of filing false paperwork and changing court records to make it look like Sledge had appeared before him instead of before Judge Gunter Terry. What Sledge failed to understand, or refused to accept, was that what he was describing was not a conspiracy, but rather the standard legal process of amending charging documents. Under Florida law, prosecutors are permitted to file amended informations to correct errors, add charges, or modify allegations based on new evidence or legal review. The no-action notation Sledge kept referencing simply meant that certain charges had not been included in the original information filed on December 11, 2024, not that they had been dismissed. When prosecutors filed an amended information to add those charges, it created the appearance to Sledge that charges had been dismissed and then reinstated, when in reality they were simply being added for the first time through proper legal procedure. But Sledge was convinced this was evidence of corruption and fraud.
I think we've discussed this before, Mr. Sledge, that there was some sort of Scrivener's error that was subsequently changed.
It says right here, on 12, right here, it says no action for aggravated battery, use a deadly weapon, possession of a firearm, no action. Judge Gunter Terry on 12/11 right here says no action for that one. 12/11, no action. This is the original from Gunter Terry. Now you come back and you change all the paperwork right here. Like I've been in front of you on 12/3 right here. It say 12/3 Gunter Terry.
We're not in front of me on 12/3.
Well, it say right here. This is the summary right here. I'm trying to show it to you. I'm gonna show you everything right here, right now in court. You changed it online. It showed the note right here where it was changed, the benchmark. You put the charge back, aggravated battery. You put the felony. It was changed right here. It says from 12/12 to 12/11. You put my name on there for Gunter Terry for 12/12. You changed it from 12/3 to 12/5 right here. You put the charge back. Come on, take it to him. Go give it to him. You can give it to him.
Man,
sure. You can give it to him. Not only that, come on. I was charged with premeditated first-degree murder on December 1st.
Mr. Sledge, one thing at a time, please.
I'm just saying, man. I'm tired of being in jail. I got tased.
I understand
you
it.
Help me though with the tase part. I ain't mad at the police department no more.
Okay,
I'm gonna tell you.
You understand? I don't investigate issues.
But
That's
you-
not my
but
job.
see,
That's
a-
not what
a
my
wrong
role
for
is.
a right, you got-
Mr. Sledge, can I finish my sentence, please? Say again?
I'm showing you right here. Well,
Your attorney has the paperwork you wanted
No,
me
I'm
to
talking about
see.
the probable cause the night I went to jail. It doesn't have no warrant, and it says it does not have any indictment or any filing information. I wasn't even supposed to go to jail. Here, take this up there to him too, please.
Sir, when you're at first appearance, typically an information hasn't been filed because you've just been arrested.
For premeditated murder, it do. An indictment has to be filed.
And
I'll show it to you.
that has,
Well, why I'm still charged with premeditated? I ain't got no indictment. Why am I still
you're charged with attempt.
It says premeditated.
I'm looking at it right now. It says attempt.
Attempt. Why is it still attempt when she got shot in the leg? She just said it at the bond hearing.
Amended information that was filed on January 14th of 2025 says attempted first degree murder with a firearm.
First degree murder, December 1st.
Attempted.
I'm telling you what I was
It's been
charged.
amended, Mr. Sledge.
But why did you take me to jail for premeditated first-degree murder? You have to give me an indictment for that. Ain't nobody died for somebody that was shot in the leg.
It's been changed.
I need help from Donald Trump, them, and all the black people out here, if y'all listening. Please help me. They trying to kill me. They lying, falsifying charges. If y'all see this on Facebook, come and help me. Send Oprah Winfrey, all the people, because they harassing this black
Mr. Sledge, do you want me to read this, or do you
my bad, I'm
do you want me
sorry.
to listen to you?
Listen to me. Please listen to me.
You need to just, you've come out here, and I'm going to make sure the record's clear, in a manic, excited way. I've asked you to let me read what your attorney's trying to show me that you've asked him to show me. And the entire time he's trying to explain it to me and give me time to read it, you're talking with the microphone an inch from your face in a way that I can't hear anything but you. So can you please allow me the time to read what you're...
Sledge's accusations escalated as he handed documents to his attorney to show the judge, all while continuing to rant about how the charges had been changed and how he had been arrested on a warrant that doesn't even exist. When the judge tried to review the paperwork Sledge wanted him to see, Sledge refused to stop talking, speaking directly into the microphone in what the judge would later describe as a manic, excited way. Sledge demanded help from Donald Trump, Oprah Winfrey, and all the black people out here, claiming on camera that the court was trying to kill me and falsifying charges. He urged anyone watching on Facebook to come and help me and to send public figures to intervene. The judge, clearly losing patience, finally stopped Sledge mid-rant and asked directly, "Do you want me to read this, or do you want me to listen to you?" When Sledge said he wanted the judge to listen, the judge delivered a sharp rebuke. He pointed out that Sledge had come into the courtroom in an agitated state, demanded that his attorney show the judge certain documents, but then talked nonstop with the microphone an inch from his face, making it impossible for anyone to hear anything else or for the judge to actually review the materials. The judge stated firmly, "Can you please allow me the time to read what you're accusing me of?" This moment highlighted one of the core problems with defendants who represent themselves or who, like Sledge, demand to proceed to trial immediately without understanding basic courtroom procedure. Sledge wanted to present evidence of what he believed was a conspiracy, but he was so caught up in his own narrative that he couldn't follow the simple instruction to be quiet while the judge reviewed the documents. His behavior was not helping his case. It was demonstrating to the judge that he was volatile, confrontational, and incapable of maintaining the composure necessary to participate effectively in his own defense. Under Florida law, judges have authority to remove disruptive defendants from the courtroom or to hold them in contempt for behavior that interferes with orderly proceedings. Sledge was rapidly approaching that line.
All right, so let me explain this to you, Mr. Sledge. An initial information was filed as attempted first-degree premeditated murder on December 11th of 2024. They also were charged with tampering with evidence and false imprisonment. Then, for reasons unknown to me, the state filed an amended information on January 8th of 2025, charging you, again, I think this is the error that was made at the time, first-degree premeditated murder with a firearm as opposed to attempt, the same tampering charge, the same false imprisonment charge, but charging you with the aggravated battery in the possession of a firearm by a convicted felon. Then, 6 days later, they filed a second amended information to fix the error with count one, which was the attempted first-degree murder. So, as far as your concerns that you think I've changed something, I have not.
You did. It says it right here.
Sir, I just explained it to you. What you're talking about is the clerk's website.
I'm talking about the
Can I
no
finish?
action. You changed the no action from
Can I
another
finish?
judge. Oh, okay. Go ahead then.
When the state filed its initial information, they didn't charge you with those two things. That's what no action means. Then they filed an amended information to include those charges.
Does that mean I was charged with it first? I was arrested for it right here. Here go the arrest paper right here. Aggravated battery, December 1st, right here. You can't tell me I wasn't. I was trying to tell me I wasn't. The lady dismissed it. You can't tell me I wasn't. There go the paper right there.
Mr. Sledge, who are you speaking to? Because you're kind of staring off into the corner while your lawyer's trying to speak
I'm
to
looking
you.
at the man right there because I'm hoping this the Channel 3 news people, because you can't give nobody a temp anyway for somebody being shot in the leg and ain't no witnesses. But all
Again,
these
Mr.
charges,
Sledge, you seem to be staring off into another corner when you're saying
I'm
that.
trying to look at this camera because I need help from the people, the black people of the world, because y'all gonna try to kill me because you falsely, how you gonna say it wasn't? You arrested me for it, but then you gonna say it wasn't? You can't, you changed it online. It's right here. It's
All right, Mr. Sledge, I've explained this to you. Your lawyers attempted to explain this to you.
I'm gonna go on the barn out. I'll show you. We'll go online. You can't change it. If I was arrested for it and you put it in the computer, that mean I was arrested for it. I'll protest. We'll get it right. And guess what they gonna say? What no action means to somebody that's not gonna charge you with it. You can't come back and charge me with it, and you already know that. But that's how you try to get my victim to come to court. She ain't no victim. You can't do nothing without her. But I ain't never should have came to jail for murder. You charge me with premeditated first-degree murder. How do you get that wrong?
Who are you speaking to, Mr. Sledge?
Oh man, y'all playing with my life, and you represented me. You took all my kids. You the one that took my kids. We done had it out of court before. I done told you one time. Oh man, you keep trying to pull this stuff.
Once the judge was finally able to review Sledge's documents and explain what had actually happened, the legal reality became clear. An initial information had been filed on December 11th, 2024, charging Sledge with attempted first-degree premeditated murder, tampering with evidence, and false imprisonment. Then, on January 8th, 2025, the state filed an amended information that made an error. It charged Sledge with first-degree premeditated murder, not attempted murder, along with the other charges, and added aggravated battery and possession of a firearm by a convicted felon. 6 days later, on January 14th, 2025, the state filed a second amended information to fix the error with count 1, correctly charging attempted first-degree murder rather than completed murder while keeping the other charges intact. The judge explained all of this carefully, walking Sledge through the timeline and showing him that what appeared to be charges being dismissed and reinstated was actually just the normal process of prosecutors correcting errors and adding charges through amended informations. The judge emphasized, "As far as you're concerned that you think I've changed something, I have not." But Sledge refused to accept this explanation. He insisted the documents showed the judge had changed the no action status and put charges back that had supposedly been dismissed. He pointed to his arrest paperwork showing he had been arrested for aggravated battery on December 1st and argued that if he was arrested for it, then the no action notation couldn't mean the charge wasn't originally filed. It had to mean it was dismissed. The judge attempted to explain that no action simply meant the state didn't charge him with those specific offenses in the initial information, but that they were later added through amendment. However, Sledge continued arguing and refused to back down and exhibited strange behavior. This behavior revealed that Sledge was not engaging with the actual legal proceedings in front of him. He was performing for an imaginary audience, convinced that his case was part of a larger conspiracy. His references to needing help from public figures, his claims that the court was trying to kill him because he was black, and his insistence that paperwork had been falsified all suggested someone who was either experiencing mental health issues or who had become so consumed by jailhouse legal theories that he could no longer distinguish between legitimate legal procedures and persecution. Either way, his behavior was doing catastrophic damage to any chance he might have had at mounting an effective defense.
Sledge, you stated something about me taking your kids.
Didn't you represent my kid? You took my children from me. Tamara?
Well,
You the DCL, you the judge. I remember. In 21. You the judge. I got the paperwork on and everything.
I wasn't the judge here in 2021, sir.
Okay.
That was all done before I was a part of that case.
Yeah, okay, I know it. You brought me out here. I come from prison. One thing about you, you like to hide paperwork. That's why I keep showing that you changed the stuff online. You can't say, oh, they didn't charge you with it. You took me to jail for it. So how you didn't charge me with it? I was arrested and put in handcuffs for aggravated battery. You can't.
And Mr. Sledge, for at least the fifth time, I'm pointing when you're talking, you're looking
And how would it
at
say
nobody
no?
in particular. Are you addressing the court?
I'm addressing the world. I need the world to understand what's going on, that you're trying to kill me. I'm a black man, and you're falsifying evidence in the charge with the police department. They charged me with first-degree premeditated murder. There's no reason to take me to jail. Y'all done took all my clothes. You stripped me butt naked when you didn't have no warrants. I got all the documents.
Right.
There's no warrant.
What date are you asking for, Mr. Kleins?
You got me in
All right,
jail.
August 27th. Thank you,
Thank
Mr.
you.
Sledge.
I need help from the black people. Y'all help me.
Mr. Sledge, I'd appreciate it if you could have a calmer tone next time you come in.
As the hearing concluded, Sledge made one final explosive accusation. He claimed the judge had taken his children away in a 2021 Department of Children and Families case. The judge immediately corrected this false claim, stating he wasn't even on the bench in 2021. But Sledge refused to accept the explanation, continuing to accuse the judge of hiding paperwork and changing records online. Throughout the exchange, Sledge kept staring off into corners of the courtroom, admitting he was addressing the world rather than the court, pleading for help from Donald Trump, Oprah Winfrey, and all the black people because the system was trying to kill him. The judge's final words were measured but carried a clear warning. "Mr. Sledge, I'd appreciate it if you could have a calmer tone next time you come in." That seemingly mild statement masked serious legal consequences. Sledge's behavior, constantly interrupting the judge, refusing to allow the court to speak, making false accusations against a sitting judge, could constitute criminal contempt of court under Florida law, punishable by up to 6 months in jail and fines. More critically, his wild conspiracy theories and inability to engage rationally with basic legal explanations had created a record that could support ordering a mental competency evaluation before trial. His paranoid claims about people trying to kill him, his performance for imaginary cameras, and his fundamental misunderstanding of legal procedures all suggested someone who might not be competent to stand trial. By making demonstrably false accusations on the record, Sledge had destroyed his own credibility as a potential witness. Any jury would see a defendant who believes he's the victim of an elaborate conspiracy involving falsified documents, changed court records, and a racist plot to kill him, claims the judge systematically debunked. Sledge was facing attempted first-degree murder with a firearm, which carries a mandatory minimum of 25 years to life under Florida's 1020 life law, plus additional charges that could keep him in prison for the rest of his life. His insistence on going to trial immediately without allowing his attorney time to prepare was legal suicide. The tragic reality is that Mr. Sledge appeared to be a man in crisis, whether from mental illness, incarceration stress, or jailhouse legal theories that had disconnected him from reality. His trial was set for August 2025, but if he continued refusing legal assistance, making wild accusations, and performing for imaginary audiences instead of engaging with his actual case, his fate was sealed. He would be convicted, sentenced to decades in prison, and spend the rest of his life blaming a conspiracy rather than accepting responsibility for the shooting that put him behind bars. The judge's request for a calmer tone wasn't about politeness. It was a final warning that Sledge's behavior was destroying any chance he had at justice. Let us know if there's a case or courtroom interaction you'd like us to cover in the comments below. Thank you for watching, and don't forget to subscribe and share so we can help foster a more informed society.